Hello there, and welcome back to our interview series on providing content to help the federal workforce. This one, we're talking about federal employment law. My name is Brian Kuhn, certified financial planner with Wealth Enhancement, 24 years in the financial planning business, and author of Total Compensation, a practical guide to federal employee benefits. Today, our guest is Vijay Mani. He is a federal employment law attorney and partner with Thatcher, Zavaro, and Mani. Over 15 years experience representing public sector employees, victims of workplace discrimination, harassment, retaliation, unequal pay, and unlawful termination. He's served as a faculty member for the Maryland State Bar Association's Employment Law Institute, teaching mediation courses, and is admitted in Maryland and the District of Columbia. Vijay, thanks for joining us today. Appreciate the opportunity.
Thank you for having me, Brian. Appreciate it.
Lots to cover. Let's start with your background in law and the typical case you're seeing currently for some context.
Sure. As you mentioned, I have over 15 years of experience in employment law, and more specifically with respect to federal sector employment law. It's difficult to describe what a typical case is because it varies. Even within the federal sector, it varies. So I think a good place to start would be just to talk about the different types of federal cases and the different avenues that federal employees may have. Obviously, you mentioned that amongst the specific practice areas I focus on, it includes workplace discrimination, harassment, retaliation, unequal pay, retaliation and terminations. If those are the types of actions that a federal employee wants to challenge, right, and they believe that that adverse action is based on discrimination due to a protected category, that would be covered under Title VII. And those protected categories are, race, gender, ethnic origin, religion. The ADEA covers age discrimination. The ADA, or the Rehabilitation Act for federal sector employees, it covers disability discrimination. So if those sorts of adverse actions that I mentioned may be due to one of those protected category discriminations, then you would want to file a complaint with the EEO office. Each agency has its own EEO office. You start there by contacting an EEO counselor, and then the case proceeds that way. Career civil servants, if they have an issue with an adverse action, such as a suspension, demotions, removals, and they believe that it's a prohibited personnel practice, and there are a litany of things that describe what a prohibited personnel practice is. In that instance, you'd want to file an appeal before the Merit Systems Protection Board, because you have that protection under the Civil Service Reform Act. Even before you can get to the MSPB, you would have an internal process where you'd be submitting a written reply to the charges that are being made to justify a removal or adverse action. You could present an oral reply before a deciding official, then you get a written decision, and then go to the MSPB. If you're dealing with cases involving whistleblower protection, if you engaged in some kind of protected activity and were retaliated against for that, and again, there are specific categories of protected activity, then you may want to file a complaint with the Office of Special Counsel, the OSC. And so each of these different avenues, they have specific deadlines, they have specific processes and procedures. And in addition to all of that, a federal sector employee may have a negotiated grievance process as a member of a union. And in that case, they would be able to take advantage of that grievance process by filing a grievance within their collective bargaining agreement. So, it's important to understand that there's a wide variety of cases. There are a wide variety of tribunals to which you can appeal. So federal workers have a lot of protection, obviously more so than private workers do. So, a typical case could be any of that, right? Could be somebody challenging their removal Could be somebody claiming discrimination or harassment or hostile work environment. It could be somebody, challenging a policy or procedure that wasn't properly followed through a negotiated grievance, or it could be someone that's trying to file a complaint under the Whistleblower Protection Act or the Whistleblower Protection Enhancement Act, which all could also apply to contractors. So it's a wide range of cases, and these cases typically could last anywhere from months to years. It just kind of depends.
Yeah. So what are the themes that you are seeing within the federal workforce as they reach out to you?
Yeah, much like a lot of what some of the agencies are seeing, especially these tribunals. The Merit Systems Protection Board, for example, has seen a shocking increase in the number of cases, and so we've also received a lot of calls and are being consulted with for many issues related to the actions of the incoming administration, specifically mass layoffs, right? When there are a lot of layoffs that are taking place involving civil servants, career civil servants, certain policies and procedures have to be followed, and so if a policy or procedure is not followed, for example, let's take reductions in force. There are regulations that require an agency to define the specific unit or division that's being downsized, the competitive level of the federal sector employees who are, being proposed for layoffs. There has to be a retention register that ranks employees based on their tenure with the federal government, their length of service specific to an agency, whether or not they have veteran status, their performance appraisals, what do they say? Based on all of those sorts of metrics, layoffs are then proposed and implemented. What we're seeing now is, mass layoffs that haven't followed policies and procedures. And one of the tribunals I mentioned earlier, the Merit Systems Protection Board, they hear appeals on RIFs where policies and procedures have not been followed. So that is, a common theme right now. It's probably one of the more prevalent ones, is you're seeing a lot of challenges to layoffs where policies and procedures were not followed. These sorts of MSPB appeals, you can file individually if you were laid off, and if the Merit Systems Protection Board hears your case and determines that, that the RIF was done contrary to regulations, you would be entitled to reinstatement and back pay. More broadly, right, when you have certain executive actions that result in these sorts of directives for mass layoffs, a lot of those are being challenged by different unions and advocacy groups in court. Some of them have been sent back to the MSPB because you have to exhaust administrative remedies. In other instances, there have been injunctions that have been granted, pauses to these sorts of mass layoffs until there can be a hearing deciding on whether or not there is actual legal authority to proceed that way. So, you have certain unions and advocacy groups acting on behalf of federal employees, and then federal employees themselves have certain processes they can take advantage of. Now, if you're part of a bargaining unit and you're covered under a CBA and you're RIFed, your only option may be to go through that negotiated grievance process rather than to the Merit Systems Protection Board. The reason that distinction is important is if you start a process, you can only elect one process. So it's important that you elect the right one. One other thing, and this is something I should have said at the beginning, but we're having a discussion generally about federal worker employment rights. it's going to vary based on each person, right? And my advice would always be to consult an employment lawyer who specializes in federal sector employment, because there may be avenues for relief that you're not even aware of, that are specific to the position you're in and the circumstances surrounding your adverse action. So, while this discussion is designed to be, kind of a general primer, I would recommend that you do speak to a federal sector employment attorney, because what's, actually the best course of action is going to vary based on specific agencies, specific positions, specific circumstances.
Yeah, that was going to be my next comment. Everything you're describing sounds like a lot for an individual federal employee to already know and be familiar with, especially for those who have never been through anything like this before, which is, I guess, everybody. So how does an individual federal employee assess the legality of something that's happened to them or might happen to them? It's probably, talk to someone in your role.
Right. I mean, the difficult answer is that they can't. It's going to be very difficult for them to assess the legality of what's happening. But what they should be aware of, at the very least, are the different avenues in which they can challenge an action that they think may be illegal. Obviously, they should talk to an attorney who can tell them more. But some deadlines you want to keep in mind, right? If you want to go to the MSPB, you typically have 30 days to file an MSPB appeal. If you want to file something with an agency's EEO office, you have 45 days to do that. The OSC, if you're going to raise certain whistleblower, Protection Act violations, I think the language is within a reasonable amount of time, right? Bottom line is, don't wait. If you're a federal government employee, you should have your affairs in order. You should contact an attorney. You should try to move forward expeditiously so that you don't lose your right to appeal. Again, that's different from in the private sector, right? In the private sector, sometimes you have 3 years to bring certain claims. You have, 180 days to raise discrimination claims. Within the federal law, sometimes 300 when you're talking about there being some crossover with state laws. Not so much in the federal sector. You have a much more truncated deadlines, and so it's important to be aware of those and talk to someone right away so that they can best advise you on the likelihood of this action being illegal and what you should do about it.
Mm-hmm. I saw it announced publicly that some guidance about documenting what your occupation entails and what directives you are given. Are those examples of things that some tips that federal employees who are remaining employed should do? What are some other tips to keep in mind right now?
Yeah, absolutely. I think that because there are issues involving employment classification, right? Based on your position and what you're classified as, you may be entitled to merit systems protection. I would advise all federal government employees to download their OPF, their official personnel file. Have a copy of your SF-50. Document any and all communications related to your position and any adverse actions you may be worried about. We talked about being aware of deadlines. If your agency or your unit is covered under a specific union, talk to a union rep. Even before there's an action, talk to a union rep. One of the things that we get here is we have consultations with federal government employees who have yet to experience an adverse action. They may be bracing themselves for one, but they want to be prepared. And so, again, don't wait to talk to someone, but make sure that you have the most important documents, describing your performance, describing your tenure, describing your value to the agency, and anything regarding your classification, and of course any communications to the extent you can, right? If you have an option of picking up the phone and talking to your supervisor about what's going to happen next, or sending an email, send the email, because then you have a date stamp and you have it written. So try to document everything and be prepared, because a lot of what's going on, it's kind of a trial by fire. A lot of it's unprecedented. Some of it's rescinded. You hear of an action taken, and then a few days later that action's rescinded because it's not being done with precision, or sometimes it's not being done in accordance with regulations and policies and procedures. If you can, to analogize, right? If you're trying to defuse a bomb, right? There's specific things you have to do in the right order, and you have to know which wires to cut and how, right? And sometimes it seems like this administration's trying to defuse that bomb by taking a sledgehammer and beating it with it, right? It might cause more problems, and it certainly has caused more problems and upended the lives of a lot of federal government employees. And so right now, I do understand that a lot of them are bracing themselves for what might come next. But I think if you follow some of this advice and consult with people early, you'll be better prepared.
Yeah, I agree with that. A lot of uncertainty. So that's one of the themes I'm seeing is we'll on the financial planning side is we'll work with people to try to figure out next steps and financial decisions and access to liquidity in relation to these cases, not only because we don't know how they'll turn out or how they're supposed to go, but specifically how long they'll take, right? Is there any thoughts on that? I think you mentioned earlier on that it could take a while, but these claims or the lawsuits that we're hearing about in the news, is there any general guideline on the timeline for them to go through the court system?
Right. So that's it's a tough question. I can try to provide ranges, and we can talk about it in two different ways. Let's first talk about some of these actions that are challenging the administration's directives in the court system through unions and advocacy groups, right? In those instances, they are typically asking for an injunction along with filing a complaint. And what an injunction does is it tells the judge, while we're trying to figure out if this is illegal, and while we're preparing for a hearing and getting the appropriate documentation, you can't allow them to execute this directive or order, because irreparable harm could be done to the people that are affected. And so what courts will do is, and this has been done with a lot of these orders. There have been injunctions that have been granted, and there's been a pause against these sorts of layoffs, pause against certain actions. Typically, those injunctions are dealt with within a couple of weeks, and justifiably so. It's handled within weeks because of the irreparable harm that is happening. So once there's a pause, to actually get to the hearing to talk about the merits of the complaint, that may take months. So while there's a pause, that pause could be lifted at the end of the hearing if it doesn't go in the favor of these unions or advocacy groups. Now that's for these legal challenges to some of these actions. Individually, if you are challenging an adverse action before the EEO, that's a pretty long process. It's one where initially it's called an informal process, where it's supposed to take weeks, where you're working with an EEO counselor and they're trying to see if it can be resolved. If it doesn't resolve, you have a right to file a formal complaint. That complaint then gets investigated, right? Typically investigations are 180 days. After that investigation, you have an opportunity to have a hearing before an administrative law judge. That process could take months, and sometimes even longer, much longer. So if you're challenging something based on discrimination or retaliation, you're talking about months to a year, if not longer, before you get to a resolution. That's not to say that you can engage informally in negotiations to resolve it through settlement or some other avenue, for a remedy. With the MSPB, against, you initially challenge the adverse action, suspension, removal through that process I described earlier, where you're submitting a written reply to the charges and having a quasi hearing before a deciding official, and then you get a written decision that could take weeks to months. Then if you appeal to an MSPB administrative law judge, that could take months, and then you ultimately get a decision from an MSPB judge after a hearing and a truncated discovery timeline. Then if you want to go to federal court, and you don't like the decision that you got from the ALJ, you have to get a final decision from the board itself, the Merit Systems Protection Board. And so that process could take months to years. So it's difficult to put a precise timeline, but one thing with the MSPB is there is a push to get these matters resolved prior to the full adjudication. So there are several opportunities to resolve it along the process. One other thing that we're seeing now is these mass layoffs, right, and shrinking and downsizing certain agencies. These tribunals are not immune to that, right? Along with other agencies, the EEO offices may be understaffed. The MSPB, which may already be understaffed, may not be able to, as efficiently handle the cases they used to handle because of the deluge of cases, but also because, they might be facing staff shortages as well. So I think you have to be prepared that this could be, something that is definitely a marathon and not a sprint. You may not see relief immediately unless you're able to negotiate something informally with the agency.
Yeah. All right. Well, great stuff. We appreciate it very much. We're going to arrange to have you back as this progresses. We would be happy to do so. So how can people get a hold of you if they want to talk about some of these topics individually, and what should they expect from that conversation?
Yeah, absolutely. They can reach out directly to the firm, and I provided the contact information for the firm. My email address is vm@thatcherlaw.com. They could email me directly. They can reach out to the firm by using our number 301-441-1400. I've included a QR code so that they can go right to my page and contact me that way. They can set up a consultation appointment and we can talk specifically about, their concerns. Some concerns, there may not be a legal solution, but even if there's not a legal solution, there are best practices in employment issues in general, and we're well versed in those. And so they can reach out and ask for me, and I'm happy to consult with them on any issue related to their employment.
That's great. We appreciate it very much. And I'll say briefly at the end, Wealth Enhancement Group and I are able to help on the financial planning side. So if you're going through some of this and want to try to visualize your future, visualize your retirement, or just talk through anything related to a personal finance matter, we are also available, and there's no charge to talk. So thank you all for your time, and we'll see you on the next one.
Thank you, Brian.
Mm-hmm.